Good afternoon, guys. I'm Faith Austin De La Fuente, a fourth-year base crime student, and our topic for today is all about the Rule 117 of Rules of Court, which is the motion to quash. A motion to quash is a critical defensive pleading available to an accused in a criminal case to challenge the validity of the complaint or information before entering a plea. It is governed primarily by Rule 117 of the 2000 Revised Rules of Criminal Procedure. So Rule 117, motion to quash, according to Section 1, time to move to quash, that at any time before entering his plea, the accused may move to quash the complaint or information. According to Section 2, form and contents, the motion must be in writing, signed by the accused or his counsel, and must distinctly specify the factual and legal grounds relied upon. The court shall consider no grounds other than those stated in the motion, except lack of jurisdiction over the offense charged. According to Section 3, on its grounds, the accused may move to quash on any of the following grounds. First, that the facts charged do not constitute an offense. Second, that the court trying the case has no jurisdiction over the offense charged. Third, that the court trying the case has no jurisdiction over the person of the accused. Fourth, that the officer who filed the information had no authority to do so. 5. That it does not conform substantially to the prescribed form. 6. That more than one offense is charged except when a single punishment is prescribed for various offense. 7. That the criminal action or liability has been extinguished. 8. That it contains averments which, if it true, would constitute a legal excuse or justification. And lastly, that the accused has been previously convicted or acquitted of the offense, or that the case against him was dismissed or otherwise terminated without his express consent. Let's proceed to Section 4, Amendment of the Complaint or Information. That if the motion to quash is based on a defect which can be cured by amendment, for example, form or substance defects, the court shall order that an amendment be made. If the motion is based on the ground that the facts charged do not constitute an offense, the prosecution shall be given an opportunity to correct the defect by amendment. If they fail to amend or the defect remains, the motion shall be granted. Section 5. Dismissal or discharge. If the motion to quash is granted and the defect cannot be cured by amendment, or the prosecution fails to correct it, the court shall dismiss the complaint or information, or discharge the accused. If granted, the court may dismiss with or without prejudice depending on the nature of the defect. Section 6. Court's treatment of motion. The court shall rule on the motion before arraignment. Example, before plea. If the motion is denied, the arraignment and plea proceed. Section 7. Effect of granting motion. Granting the motion prevents further proceedings unless a disposition is made or a new information is filed if allowed. Section 8. Provisional dismissal. A case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. If the case is one punishable by imprisonment not exceeding 6 years or by a fine or both, the provisional dismissal becomes permanent 1 year after issuance of the order unless revived. If the offense is punishable by more than 6 years, the provisional dismissal becomes permanent 2 years after, unless revived. And lastly, Section 9, failure to move, to quash, or to allege any ground. If the accused fails to file a motion to quash before the pleads or fails to allege certain grounds in the motion, he is deemed to have waived objection to any grounds except for the following non-waivable grounds. First, that the facts charged do not constitute an offense. Second, lack of jurisdiction over the offense charge. Third, extinction of the criminal action or penalty And lastly, double jeopardy, previous conviction or acquittal. That's all. Thank you.